Welcome to our second presentation on the Fair Labor Standards Act, or the FLSA. Let's begin. When we were together during the first lecture, we went over kind of an overview of the statute, and now we're going to focus on perhaps the most important part of the FLSA, which is the one that establishes the minimum wages that workers have to be paid. Let's fast forward to that section. Here we go. So we're going to now talk about minimum wages. So what is a minimum wage? It's exactly what you think it is. It's the amount that a person must be compensated on an hourly basis when he or she is employed in a job that is covered by the FLSA. And our current minimum wage, and it's been our current minimum wage for quite a while, is $7.25. This is statutory. There is no kind of cost of living adjustment built into the minimum wage. It's a political decision that our leaders in Washington decide from time to time. And so it's hard to know when that amount will go up. Or how much it'll go up when it does go up. It is also true that, of course, our legislature in Texas could increase the minimum wage before action in Washington. That has not usually been the pattern that we've seen, though. But certainly when one is monitoring this, it's a good idea to keep an eye out for what's happening in Washington and what's happening in Texas. In Austin, so to speak. So right now we're at 725. If that changes, I'll update the materials in the course so you can see what the new rate is. Now, the traditional way that wages are paid is an hourly amount. If I work 7 hours and my hourly rate is $10 an hour, then I'm going to earn a gross amount of $70. Obviously, taxes will need to be withheld, so it won't be exactly $70. That's a very common way for folks to be paid, but there's lots of other ways that people can be paid. And we're going to talk about those methods as we progress through this module. So let's look at an example. This person is actually paid $9 an hour. So we'll say it's a man, we'll say it's Bob. He has a pretty traditional job. But he also has some other components to his pay, and this isn't unusual, even for an hourly paid individual. So he has earned $5 in commission for his 40 hours of work that he's performed, and he is entitled, or he earns credit for $20 in terms of room and board. For example, perhaps his employer buys him lunch. That's provided for him. This isn't an unusual arrangement, especially when a person works in somewhat of a remote area and there aren't choices of cafeterias or restaurants or things along those lines. Sometimes the employer will provide lunch, and then that counts as compensation for that particular worker. So in this case, we have 9 times 40, or $360. So this is just the multiplication of 9 times 40. And then we have the $5 here and the $20 here. These numbers are added up to get us this number. We see that he worked a total of 40 hours, so we're going to take this number, the total earnings for that week, and divide it by the number of hours that he worked. If he only worked 35, then obviously we'd use 35 here. So we divided it, and Bob's actual wage rate isn't $9 an hour, it's $9.63 an hour. You may be thinking, well, why do we care? What's the significance of that? Well, it becomes significant when Bob works his 41st hour, because at that time, Bob will be entitled to whatever his wage rate is times 1.5. If he's paid only $9 an hour, 1.5 would be what? 9 plus 4.5, or $13.50. So if he didn't have these extra payments to him, then he would be earning only $9, or $13.50 an hour. But that's not Bob's situation. Bob actually earns this, even though he probably doesn't even think about this as earnings, but it counts. So he ought to earn $9.63 and 1/2 that, which would be what? 4.5 plus half of 63, so we'll say 32 cents. So we'd add these three numbers up. Well, let's see what we have here. Do it quickly. So this would be, put a 0 here. So we'd have 5, and we'd add 8 and 4. So I think the math is $14.45 an hour. So Bob might be expecting for that 41st hour to only earn this amount because after all, that's his hourly rate times 1.5. But really, he ought to be earning this amount, which is his adjusted or his real hourly rate times 1.5. This is a very common problem for employers to deal with because employers will oftentimes just take this 9 and multiply by 1.5. But you can see in this situation, Bob is being paid almost $1 less an hour for his overtime than he's entitled to. You may think, well, I mean, that's not a lot of money. I mean, maybe Bob only works a few hours of overtime a year, and okay, so it's, $20 or $50 or something, not a ton of money. You're right, it's not a ton of money, but there may be 50 people in Bob's situation, and it may be that Bob routinely works overtime. And so in this situation, we start talking about some real money. And because this would be a willful violation, because there's just no argument that it's really not $14.50, there would be the possibilities or probabilities of liquidated damages. And the employee, Bob, in this case, could look back 3 years to get all of those sums of money paid for. So we could be talking a very significant amount of money if those facts that I just mentioned happen to be true in this case. So it does require that the employer be sensitive and be aware of these issues. Nowadays, these types of issues are usually resolved via having a relatively sophisticated payroll systems. But you have to make sure that the right information is being documented in the system. For example, this $20 isn't actually paid to Bob. You have to decide, well, what are the values of his meals that he's getting for free? Probably the commission is going to show up pretty readily, but some of these benefits might not appear in a direct way, and you can see how they could be really, really important to this calculation. We already talked about the fact that states can have higher minimum wages, and certainly locales even, if a particular state allows what they're called home rule jurisdictions or cities that can have their own statutes or regulations or ordinances in this area. Then you might find a particular city might have a higher minimum wage than the overall state. And that could make sense just from an administrative perspective. For example, think about it. The cost of living in Austin is significantly higher than it would be to live in Gunter or in Denison or in Madisonville or any other small town in Texas. So it makes sense perhaps to have a higher minimum wage in areas where the cost of living is higher. There is also the option of having sub-minimum wage payments. The first thing to say about these is that they are not popular with their employers. There's two categories that we see with sub-minimum wage. One is workers who are under the age of 20, the kind of newbies, people starting out. The idea is that a person who hasn't been out in the workforce for very long may not bring enough assets or skills to the position to be able to persuade an employer to give him or her a chance at the minimum wage rate. But if the amount can be dropped, then the employer might say, well, this person may not have sufficient skills to justify the minimum wage, but perhaps they might be sufficiently skilled to justify a lower pay rate. And so this allows people to kind of get into the market, develop some skills, and then of course quickly move up to the minimum wage and hopefully even in a higher than minimum wage rate. The challenge with this is that the employer cannot displace other workers to hire. So, it can't be this kind of turnover, whereas, oh, you just had your 20th birthday, so you're out of here. So now we're going to hire a younger person so that we can offer them the subminimum wage law. Now, this would not be an example of age discrimination under federal law, because as we recall, we talked about you have to be 40 years old to be protected under the Age Discrimination in Employment Act. But still, in this case, 20-year-olds, people who are no longer eligible for the subminimum wage, do have some level of protection from being dismissed because the employer wants to hire the younger folks. I'll tell you, as a general rule, because our minimum wage currently is so low, this isn't so much of an issue. Usually, especially in the larger metropolitan areas, the in-hire rate is going to be sometimes above and sometimes well above the minimum wage that's currently being offered. Another category in which we're allowed to offer sub-minimum wage rates is for disabled workers. And these can be physically disabled or intellectually disabled individuals. This can also be for apprentices and people who are learning on the job. We talked before about how interns have to be paid. And I talked about them being paid at the minimum wage rate, but you can actually pay them less than the minimum wage. You have to pay them. That's not really in dispute, but you don't necessarily have to pay them at the minimum wage rate. The problem with taking advantage of this sub-minimum wage category is that there is a lot of bureaucracy associated with it. And you can kind of understand why there is this bureaucracy. I mean, the Department of Labor doesn't want a ton of people to be paying a sub-minimum wage rate. Imagine, for example, that you had a worker who had a minor disability, or at least one that did not significantly affect his productivity. And let's say the economy is kind of soft and it's hard for everybody to find a job. Well, an employer might say, well, we'll latch on to this worker who has a mild disability. Maybe he doesn't have full use of his left hand, but he doesn't really need his left hand in this job. He's a right-handed person in terms of writing and doing tasks, and so honestly his left-hand disability isn't going to impact his work, but we can claim he's disabled because he is, and we can pay the sub-minimum wage rate. That's what the Department of Labor doesn't want to have happen. They want to offer the sub-minimum wage rate only to individuals who really aren't able to perform at the level that a typical person would perform, either because of a disability or because they are learning. As a result, this whole sub-minimum wage category is not routinely used by corporate America. My guess is that there are some people in other industries, maybe charitable industries, that do this. For example, maybe I don't know this for a fact, but organizations like Goodwill or Salvation Army might use this when they are hiring individuals who have severe or profound disabilities, and to help train them in job tasks and help them have an opportunity to participate in the labor market. So let's talk about a scenario here. So Mary is an apprentice, so she falls into this category. She doesn't have a disability in our story, but we could certainly, the story would also work if she were disabled. So Mary's an apprentice. She's learning how to assemble and install kitchen cabinets. The employer follows all of the rules and pays her $5.50 per hour. This is obviously less than the minimum wage of $7.25. The employer can do this only if it obtains a certificate permitting it to do this with Mary. So again, you have to balance how much are you really saving when you have to complete all this paperwork. So it's a trade-off for the employer to consider. And then, of course, will Mary be willing to pursue this opportunity if she isn't earning the minimum wage? Let's consider a few circumstances where we don't have an hourly wage rate. In this case, Mary, of course, is earning an hourly rate. But there's 4 other ways that we see typically workers are compensated. One way is through a salary. A salary is a system in which a person is paid a set amount of money for a certain number, or typically a week's amount of work. That person may have worked a lot that week, maybe even 100 hours, or they may have worked relatively little that week, maybe 20 or 30 hours. Yet their pay won't change from week to week. So their number of hours worked does not directly affect how much they are compensated. That is what we call a salary. And we'll talk more about this going forward. Then we have piece rate. This is when I am compensated based upon how much work I perform. For example, let's say my job is to sharpen knives. Well, every knife I sharpen, I get compensated for that. If I'm a seamstress, every hem that I put in a pair of pants, I might get compensated for. There are some advantages and disadvantages. Number one big advantage is that it encourages people to be productive. As you can imagine, if you're in a piece rate type of enterprise, people are going to produce a lot more sharpened knives than if you're in an hourly wage situation, because the person isn't directly seeing a financial benefit to being especially productive. A problem with piece rate can be, though, that well, more than one problem happens. One problem can be that the quality of the work may diminish. I may not produce as sharp a knife if I am trying to get as many knives produced as possible. My hems may not be as straight, and my sewing may not be as straight or as attractive as if I we're taking more time with each piece. There can also be safety implications. If I'm sharpening knives, obviously I can get hurt in that process. And so if I'm trying to do them as quickly as possible, I may take some may disregard some safety procedures. Obviously, that would also work with the seamstress, perhaps doing some things that might not be as safe. So there are reasons why piece rate work can make sense, and then there are reasons why they can also not make sense. So you have to consider the totality of that when you're designing your compensation systems. Then we have commission systems. These are usually for individuals who are in the sales aspect of the job. And this also has benefits and detriments. It's kind of like a piece rate situation wherein a worker is compensated based upon how much business he or she is generating for the employer. This, though, can also present some problems. For one thing, usually commission sales workers are also expected to do some other tasks. It may be just housekeeping tasks. It may be some kind of paperwork tasks. It could be doing some signage and other tasks associated with that. Well, as you can imagine, if you are paid on a commission basis, you're not very motivated to want to vacuum the department, because when you're vacuuming, you're literally not earning any money, because there's no possibility that someone's going to walk up to you as you vacuum and say, I really want to buy that ring from you right now, right? It's just not going to happen. So you're on the clock, but you're not actually in a position where you're going to earn any money. So for many commission folks, it feels like they're kind of donating their time to the employer when they're doing those tasks, and that can result in morale issues. It can also mean that those tasks aren't performed very frequently, or they aren't performed very well. So that's one problem with a commission pay system. Another problem can be arguments about who actually earned the commission. Especially if it's a big purchase, it's not unusual for a customer to come more than one time to kind of make the decision. Let's say it's a jewelry store, and somebody is shopping for an engagement ring. We'll say it's a man shopping for an engagement ring for his fiancée. He's going to spend maybe a few $1,000s on this. Almost certainly it's not going to be a one-time purchase, or one time you come in and make the purchase. He will be shopping lots of different places. He'll probably bring his girlfriend in sometimes. Maybe he'll want to surprise her, so he may want to buy it independently. And so there's lots of things that are going on. Well, the first person maybe who helps him that first day maybe spends an hour with him. The next time when he comes in, when he's ready to buy, that person isn't there. So another person helps him for 10 minutes, making sure it's the right ring, handling the transaction. Well, now there's a debate. Well, who should get the commission? The person who spent an hour or the person who spent 10 minutes? And so you can see how deciding how to divvy that up can become a source of tension. And even when there are clearly defined rules, it may still not be obvious how that plays out. For example, probably the rule in the facility is going to be that the first person gets probably the whole commission. But the second person maybe doesn't ask, well, who helped you last time? Or maybe the person, the customer doesn't remember, maybe doesn't want to say who that person was. And so the paperwork might not be correct. Or it could be that the second person just lies and acts like, oh, I'm the one who helped him. And then, he may get away with it sometimes because obviously the other worker isn't going to be there at all the times. But if it happens enough, it can come to be a real source of tension in the workplace. I've seen situations where people have come to blows, where people have one situation where somebody who was an aggressive salesperson used to close display cases on the fingers of her colleagues to kind of get even when she thought a sale had been stolen from her or something along those lines. Another thing that happens is that sales or commission employees will kind of tag a customer. The customer walks up and then one commission person will immediately kind of descend upon them in this very aggressive way, and that's not a very comfortable feeling for the customer. But now this person has descended upon this customer, and now the customer is kind of associated with that person, and the customer really can't easily change. Usually it's that first connection is going to be who gets the commission. And so that can cause challenges in the department where you have somebody who's always the first who aggressively kind of noses in to make the commission. So again, it's a system that makes some sense, but it has some opportunities as well. The reason I'm raising these, by the way, is that when you're thinking about designing a compensation system for your employees, you have to think through these issues. Yes, you certainly have to think about legal compliance issues, but all of these programs can be legally compliant. But you also have to consider, is this going to lead to the most success for my employees and as well as for my business? The last choice is usually something that is used in the restaurant business, although it certainly can be also applicable in other industries. And this is when a person is compensated directly by the person who is receiving the service. It's kind of like a commission, except instead of the employer paying it, it's the customer who pays it. And so we'll talk about those rules as well. Okay, so I've kind of given you an advance on these topics. I'm not going to spend a lot of time going over these since I've already kind of talked about them. So a salaried employee, the hourly rate must be equal to the federal minimum wage or more per hour. There's an old joke when I was practicing law. New attorneys, especially in large law firms, are usually paid pretty well, but they work a lot of hours. And so the joke was, maybe they're paid, $150,000 a year, but they say, I'm not even being paid minimum wage because I'm working so many hours. It's a joke. It's not serious, but you do have to consider that. If you have somebody who worked 100 hours in a given week as a salaried employee, well, that person would need to earn at least in gross amount $725. If in that week they did not earn that much money, then their compensation needs to be increased. Now, hopefully it's not a routine thing that you have workers working 100 hours in a given week, but that's the logic behind this rule. For piece rate workers, the average hour earnings during the work week must be at least at or above the federal minimum wage. So let's say that I get $1 for every pair of pants that I hem up. And let's say I average hemming 6 pants an hour. Well, that means my average pay is going to be $6 an hour, which is less than the minimum wage. Now, I won't be exactly 6 every hour. There will be 1 hour where I earn 7, another hour maybe where I earn 10. There might be another hour where I'm earning only 4. It may vary depending upon the type of hem that I'm hemming. Maybe if I'm doing a blue jean hem, it takes a little bit more work. Maybe if it's a bell-bottom hem, it takes a little bit more work. There could be all kinds of different variables in that. But it needs to, on average, I need to earn at least the minimum wage. So if I end up averaging only $6 an hour, then the employer is going to have to make up the difference to get me to $7.25. Now, the employer can certainly discipline the worker for being not very productive. So while the employer is going to have to pay the minimum wage of $7.25 an hour for that week, the employer can also dismiss the worker for not being sufficiently productive or do some lesser type of discipline. Those two are not inconsistent. They should very likely be advanced at the same time. So you can't say, well, you only produced 6 hours each, or excuse me, 6 items each hour on average, so therefore we're going to discipline you by paying you only $6 an hour. That's not going to work. You have to get to that minimum wage, even if you decide you're going to dismiss this person. Another example of a piece rate, which is a lumberjack who is paid based upon the number of trees that he harvests. So those are just some examples of how piece rate work works. The traditional piece rate work job is the seamstress or seamster job, I guess. Commissions paid to employees must also equal or exceed the minimum wage. So here you might have a situation where you have a business that is open from 8 a.m. we'll say to 5 p.m. It's a jewelry store, and so that is a total of 7 hours. And then the worker is required to show up at 9:30 to kind of open the store, get the jewelry displayed correctly, and he needs to stay afterwards until 5:30 to again resolve, take care of the till and store the jewelry, all that type of thing. So he works from 9:30 to 5:30. We'll say he takes some lunchtime in the middle. Well, he knows when he arrives at work at 9:30, there is no chance of him earning any commissions before 10. And he knows that once 5 o'clock and they lock the doors, there's no chance of him earning any commission between 5 and 5:30. Let's assume that he's had some pretty decent sales this week, so he knows that he's going to be over the minimum wage for all of the hours that he's clocked in. So basically, he is going to see this as, I'm donating an hour to my employer, 30 minutes before time, 30 minutes after time. One of the things that sometimes comes up in this situation is that he may not come to work exactly at 9:30. He might roll in at 9:55 or 9:59 p.m. And so the employer has to say, well, what am I going to do with this person? Am I going to terminate him or discipline him because he shows up late or maybe leaves early? That certainly is an option. But if he's here and he's clocked in, he needs to be compensated. I've seen this in real world where you'll have very competitive commission folks who produce really awesome sales for the employer, but they don't show up until right before they're supposed to clock in. Well, all the other workers who perhaps are less stellar in their sales are there at 9:30 doing all the work they're supposed to be doing, and then the all-star rolls in, and you can imagine the level of hostility that exists in that workplace. So what do? I mean, obviously, ideally, you're going to counsel the all-star and say, hey, buddy, we love you, we think you're awesome, but you have to be here at 9:30, and you got to stay till 5:30. And if that works, awesome, but sometimes it doesn't work. And so then you have to decide, am I going to put up with this because he generates these awesome sales, or I'm going to have to cut him loose because he's just too much trouble? And that's something that, again, it goes to a policy issue. You want to be consistent, though. If you're going to permit him to be late, then you really need to permit other folks to be late too. So it's a slippery slope. The best practice, honestly, is to have a rule, to have very defined steps that you will discipline individuals who don't follow the rule. And even if it hits the high-performing person. If you're consistent and if the employees know that you mean it when you say this, then in most cases that high performing person will get with the program because he or she can see the handwriting on the walls. But not always. High performing sales individuals have their own personalities in many cases. Many times they have pretty strong personalities. And so they may not be willing to compromise or make adjustments to keep the employment. And part of the reason why they may have that position is that they recognize that they can get other jobs, that they are going to be highly sought after because of their sales skills. And so they're not too worried about getting fired because they know that they'll land just fine. So it can be a difficult situation to manage for sure. Sometimes an employee will have 2 or more different wage rates in a week. For example, perhaps a worker might usually work the day shift, and during the day shift he's paid $10 an hour. If he works the night shift, though, he gets $12 an hour. And let's say in this particular week he has a combination of some hours in the 10 hour a week category, 10 hours an hour, $10 an hour category, and some hours in the $12 an hour category. Well, you need to do a weighted average. If he worked 30 hours at $10 an hour and 10 hours at $12 an hour, then you can see here this would be 300 plus 120 for a total of 420 divided by 40. So you would see that it would be $10.50 an hour. There may also be particular job assignments within his position that involves a premium. For example, there may be times when his usual supervisor is unavailable that he becomes the de facto supervisor and he's paid 50 cents more an hour under those circumstances. Or sometimes he may be asked to perform a job that is unappealing, that people don't like. Maybe it's outdoor work, or it's hot work, or cold work, or something like that, and so he may get some kind of premium, $1 or something an hour for that. So you have to weight all of those factors. Again, this can be done manually, but if you have a workforce where there's lots of these kind of calculations, it may make sense to automate them because you need that weighted average. Just like we talked about with Bob back in this situation, you need to make all these calculations. It only becomes relevant really when you're looking at overtime, but you have to, work under the assumption most likely that overtime will occur from time to time. Let's talk about the idea of suffer or permit. This is actually the language in the statute. And this is another area where employers are not always very conscientious. Imagine for a second that Bob is the secretary for Mary. And Mary's a pretty demanding, hard-driving manager. And she produces lots of documents in the day, and she expects Bob to get them all typed up. Bob's a pretty good worker, pretty conscientious, has strong secretarial skills, but it's really just too much to expect anybody to type up and proof and file and do all the other things that Bob has to do. So what Bob starts doing is bringing home work to do at home. He types up documents at home, he proofreads documents at home, and then in the morning he's able to load them and print them up and do all the things that happens. Now he hasn't asked Mary, can I do this? Mary maybe isn't even aware that Bob is doing this. She's fairly oblivious. She just assumes he magically gets everything done. Bob ordinarily earns $20 an hour working for Mary, working what Mary thinks is only 40 hours a week. But actually Bob is working about an extra hour a night. And so since his hourly rate is $20 an hour, he ought to be being paid $30 for those extra 5 hours. Not only is he not being paid an overtime rate, he's not being paid any because no one in the company officially knows that he's working from home. And so every single week he is being underpaid by $150. So this is a pretty big deal. And you can see how the employer, again, even if there's just one Bob, $150 every week for 3 years can add up to a very significant amount of money. So it really is Mary's job to make sure that Bob isn't doing this. Mary ought not be sending Bob emails in the evening. Mary ought to say to Bob, hey Bob, you need to get this done while you're clocked in. If you need additional time to do this stuff, you need to talk to me about, requesting overtime. You can't work from home. Mary needs to say this regularly, and she needs to hold him to it. She needs to ask him, hey Bob, it seems like, you're here for 10 minutes in the morning and suddenly you've got 5 new documents ready to go. You can't do that in 10 minutes. What's the deal? What's going on here? Are you working from home? And make sure that that is covered. So even though Mary does not officially know that Bob is working from home, she has suffered or permitted it, and that means that Bob is entitled to compensation. This gets hairy really, really fast. Let's say that Bob isn't too thrilled with Mary. I mean, it's a good paying job. He doesn't want to leave, but Mary is no friend of his at this point. So he starts keeping a diary, and every day he writes in his little diary, worked from 7:20 p.m. to 8:37 p.m. And so he records the times in this little, it may just be something in his pocket that that he jots these down. Well, guess what? That is evidence of the hours that he's worked, and there's really not going to be a way that the employer can disprove that. I mean, how can the employer prove that Bob wasn't in fact working between those two times? I mean, he wasn't at work, so there's no real way for the employer to disprove that. Bob will say that these were contemporaneous records. Maybe they were, maybe they weren't, but it's going to, again, be very difficult for the employer to disprove that. So is Bob going to understate the amount of time that he worked? Maybe, but more likely, perhaps he will maybe exaggerate it. Maybe Bob did work 30 minutes on average in the evening, checking emails, doing other tasks. But maybe he writes down 45 minutes, or maybe an hour, or maybe an hour and a half. And you can see how the exposure can be pretty significant for an employer under these circumstances. One way for employers to address this is to train the employees. If you're hourly, you can only do work from home. You should not be checking emails. You should not be reviewing files. You should not be doing anything unless you're clocked in and at work. So that needs to be a training moment. Not only do hourly folks need to be trained, but their supervisors need to be trained. And then the next thing that has to happen is that people have to be disciplined for it. So when Bob does work at home, he needs to be given a corrective. Now you might say, well, I don't want to correct. I don't want to discipline him because he's showing that he's super conscientious. That's awesome. Yeah, it is awesome. But you know what? If he's doing it and you're not disciplining him, you're suffering and permitting it. And so you need to say, and you don't have to fire him the first time, but you need to say, this isn't okay. You can't do this. If you continue to do this, we can't continue to employ you in an hourly position because we can't trust the time records that we're submitting for you. So in that situation, when Bob does say, oh, by the way, I worked an hour last night at home, I hope that's okay, Mary needs to say, well, actually, it's not okay. You can't work from home. How much time did you work? I need to record that. We need to get you paid for that. That's a given. But we also need to sit down and remind you about our policy, and if this continues, you can't work here. But even if you decide to fire Bob for doing that, you still have to pay Bob for all of the work that he's performed, including any overtime. An employee cannot volunteer his or her services to the employer doing the same type of service that he usually does for the employer. An example of this that would come up at my former employer, JCPenney, was we used to have hourly folks volunteer at our stores during the Christmas holidays. And these would be, say, secretaries and mailroom folks and people like that. And they could work at the store doing gift wrap or package pickup or things like that. It was kind of fun to do that every now and again, but they had to be compensated for that type of work. They couldn't volunteer. Now, the salaried folks could volunteer because, after all, they're being paid for the whole week, however many hours they work. Now, the actual pay rate that you pay those individuals can vary, obviously. Let's say you happen to have a secretary who earns $20 an hour. You have her do gift wrap at a retail store where that worker usually earns $8 an hour. Well, you can pay that secretary $8 an hour for the hours that she spends helping in gift wrap. And if that secretary ends up working overtime, then it will be a weighted average of those sums. But so that is the way it can be done. Of course, the employer might decide for morale purposes or just for efficiency purposes to go ahead and pay the secretary her $20 an hour, because she's not too likely to volunteer if you're going to cut her pay that much. Let's talk about on-call type of arrangements. There's lots of different ways this can happen. One way that it can happen is that a person is on call and who is pretty significantly restricted in what he or she can do. He or she may not be able to be more than, say, 30 minutes from the work area. He or she may not be able to, have any alcohol or things along those lines, especially if this employee doesn't live close to the facility. Really, there's going to be a significant limitation on what this employee can do. This is especially true if the employee is required to stay on the premises. Really, he or she isn't free to go, and so even though he or she may not be performing any work, they may even be, watching Netflix on their phone or something like that. Because they really are limited in what they can do, those hours usually have to be compensated. But there's also ways of setting up on-call so that the person is able to be free and to be able to go to their home and go out for dinner and go see a movie or whatever, with the understanding that they might have to leave in the middle of the movie. Usually that type of on-call time is not going to need to be compensated unless, of course, they get the call. And once the call happens, then they're going to have to be compensated for the time that they take to resolve whatever that particular call might be. Okay, meal periods are usually not going to be compensated. This is true if the employee is relieved of his or her duties during the meal period. But let's say I'm the receptionist and it's okay for me to eat my lunch at my desk, but I still have to man the desk in case a customer comes in or in case someone calls the switchboard. Well, under that situation, I'm not relieved of my duties, and so therefore I need to be paid as if I'm working, because I in fact am working. Another thing that sometimes comes up is that there will be rest periods throughout the day. Now, these are not required under federal law, but they are required under certain state laws. And even in places that do not require them under state law, it's pretty common for employees to have 15 or 20-minute breaks. Oftentimes in an 8-hour day, there will be 2 of these breaks. So there'll be a break in the morning, a break in the afternoon, and then of course the meal break. Generally speaking, if the break is less than 20 minutes, it has to be compensable. The idea here is in 20 minutes, the employee really can't go anywhere or do anything. He or she is kind of still a hostage of the workplace. And so because they don't really have the logistical freedom to leave, they should be compensated for the time. Once you get over 30 minutes, the assumption here is that the employee really does have some flexibility. He might be able to go to the subway a few doors down or something along those lines to get something to eat. So there's a bit of a gray area between 20 and 30 minutes. A best practice is that if the break is under 30 minutes, go ahead and compensate. If it's 30 minutes or longer, then you can call it an unpaid break. Now, it's pretty common for employers to require that the employee take that 30-minute lunch. Sometimes the employee will either accidentally or intentionally log in after 28 minutes or 29 minutes. In those situations, many employers do compensate the person for that 30-minute or 29-minute lunch as if they had been working the entire time. But discipline is appropriate. Hey, you need to notice when you clocked in or clocked out for lunch. You need to make sure it's at least 30 minutes. Now, obviously, especially if there's a line, people aren't going to be able to time it perfectly. And so you're going to need to have a range of time. Maybe the expectation is that someone will clock in between 30 and 35 minutes or something along those lines. So it is appropriate to discipline people who clock in early, but you need to have a policy in effect. Certainly if it's under 20 minutes, definitely has to be paid. If it's between 20 and 29 minutes, then the employer needs to think through the legal risks associated with having someone clock in less time. And this is good for the payroll clerk to evaluate this to see whether this is under the 30 minutes or not. Many payroll systems will flag these times so that they come to the attention of management, so that there can be reminders, warnings, disciplinary action, and also so adjustments can be made to pay. There's also rules about sleeping periods. I'm not going to cover those. There's lots of technical rules in this area, and unfortunately our class time doesn't permit us to do a tremendously deep dive in this area. If you are responsible for managing payroll, especially if there's an unusual structure to the workplace, for example, you have workers who actually live on the facility or who are on shifts for long periods of time, like firefighters and individuals like that, then you need to kind of do a deeper dive into some of these issues. Okay, let's consider the Portal to Portal Act. This is an amendment to the FLSA, but even though it's an amendment to the FLSA, people talk about it a lot, so it's kind of important to think of it in some sense as separate from the FLSA. So this act was designed to address a common issue that would come up, and that is, when does the time start? When do I start getting paid? Let's say that my hourly rate is $10 an hour. Well, when do I start earning that? What's my first minute of earning my $10 an hour? I mean, is it when I get into my car to drive to work? Or is it when I arrive in the parking lot of my facility? Or is it when I open the door to the building where I'm working? Or is it when I put on my safety gear? Or is it when I change into my uniform? Or is it when I do the safety check of the equipment that I'm using? Or is it when I clock in? And when should I clock in? At what step along that process can I clock in? And so there's lots of interesting issues, and these are very, very fact-specific issues. So it's a challenging issue sometimes to decide what is a principal activity, what is a preliminary activity. We're not going to be able to do a deep dive into this just because the case law is really, really complex, but let's address a few issues. One is that when I'm coming to and from work from my home, that is not a compensable time. If I'm traveling from location to location, though, so let's say this is my home and I go to workplace 1. Then during the course of the day, I go to workplace 2, and then I go to workplace 3. Well, this time isn't going to be compensable, but this time will be, and this time will be, but this time won't be. So and if this place is significantly farther away, then there can be an issue about, well, is some portion of this commute going to be covered? Let's say between my second place and my third place, I also took my lunch break. You can see how this adds another level of complication to this. So you have to be familiar with all the ins and outs of what's going to be compensable and what's not. Another issue is that preliminary and concluding activities, which are usually called donning and doffing. So donning here, we're talking about donning the equipment, for example, putting on the safety gear, and doffing means taking it off. You may have heard the expression, I'm going to doff my hat to you. It's kind of an old-fashioned term, but that's where we get the terms donning and doffing. But they don't have to be putting on equipment. They can be other things as well. So the issue is, are these activities compensable or not? It's not unusual in an industrial environment for the place that you park to get to work. It might be a fairly significant walk to where you're actually going to clock in. You may even need to take a bus or something from one location to another. You may wait 5 or 10 minutes in line to clock in. You may have various safety gear to put on, computers to log into, headsets to put on, all kinds of things can come up. It's entirely possible that from the time you arrive at your work until you're really ready to start the job can be 30 minutes, perhaps even longer. And so the issue is, when should my meter start running on my pay? And so that's something to definitely be aware of, and if it seems like there's a significant time here, to do some legal analysis, perhaps having an attorney evaluate when the pay ought to start. Here's a big case in this area. I'm not going to go over the case, but if you have an interest, this would be a good place to look, and you can listen to the case summary here if you have an interest. Here are some examples where courts have come down one way or the other. So fire drills are compensable, and rest periods of 20 minutes less are compensable. Employer-required training is compensable. Traveling between work sites is compensable. Waiting while on duty. So if I am at work and let's say the assembly, or let's say I work on a conveyor belt, so I'm tightening bolts as the assembly line comes down. Well, the assembly line breaks. That someone's repairing it. It's going to be 30 minutes before it's up again. I don't have anything to do with those 30 minutes. I'm just kind of standing around. Well, that time is definitely going to be compensable. Restrictive on-call arrangements when I'm not permitted to leave the facility. Meal periods when I'm not substantially relieved from my duties. All of those are going to be compensable. Let's look at the examples of non-compensable. Pre-employment tests, well, as you can see, you're not employed, so there's not really a problem there. Volunteer training that is not related to regular duties, that is outside regular hours, and that is during time when work is not performed. So this is a challenging topic to think through. You need to be careful in this area. But let's say you have some workers who in their current position, they're fine. But in order to move up to the next level, they really need to develop some skills. And so you might want to choose to allow these individuals to develop these skills. But again, you don't want it to fit into this category. You don't want to pay them for the time, but you do want to help them get the skills. For example, let's imagine that these individuals are not fluent in English, but in order to get to that next job, they really need a higher level of fluency. So you might offer some English as a second language courses. As long as it's not related to the regular duties, in other words, they don't need English skills for their current job responsibilities. You offer these outside of normal work hours, and it's during time when work is not being performed, so they're just getting the training, that's the only thing, then it's probably non-compensable. But you have to think through those issues pretty carefully. Where I talked about traveling from home to a work site, waiting to start work, and waiting after being relieved from duties for a definite and useful time. Most on-call activity performed outside of the workplace, and meal periods free of duties, and usually at least 30 minutes long. So these are some things to think about, as you're drafting your compensation policies. Okay, so we were talking earlier about, go back to this slide here. We talked about salaried, we talked about piece rate, and we talked about commissioned employees, but I didn't say a lot about tipped employees. So let's consider that particular scenario. So who can be considered a tipped employee? Well, it needs to be a occupation in which tips are customarily granted, and that the person can expect to get at least $30 per month in tips. So, things that would fit into this area would be waiters, waitresses, bartenders, porters, bellwomen, I guess, barbers, hairstylists, nail techs. There are probably others, but those are some common ones where we see a tip is likely to be a pretty significant part of the income. The rule when an employee falls in this category is that he or she must earn from the employer at least $2.13 an hour. But if the employee isn't earning enough tips to get the additional income so that she or he is averaging $7.25 an hour, then the employer is going to have to pay more. So let's say times are tough in this community. People aren't tipping like they used to. The employee is earning $2.13 from the employer, but he's only earning $5 more an hour in tips. So his total compensation is only $7.13 an hour. Well, the employer has to make up the extra 12 cents an hour to get that worker to the minimum wage rate. There's additional rules about how this is calculated. This is an area where oftentimes there's an opportunity for compliance in this area. Employees don't like to report all of their tip income to the employer because the employer is going to report that income to the IRS, and that means that the employee is going to have to declare that income, and that income is going to be subject to taxes, withholding taxes. So there's kind of a complex set of issues in this area that you have to navigate pretty carefully and pretty sensitively to make sure that you're completely complying with the law, not just employment law, not just the FLSA, but also the IRS regulations, while at the same time uh, encouraging employees to want to stay with you and want to perform good work for you. So it's a delicate situation to maneuver in. Here are two statutes that have to do with government contractors. I'm not going to spend time on this other than if you happen to be a government contractor, you need to comply with these laws. And if you aren't falling into these categories, you don't need to comply with them. And it's pretty rare for employers who aren't covered to comply with these. The few that might comply with these, who are not legally required to do so, will be doing so as a union avoidance type tool. So we are done with our minimum wage module. I hope that this has been helpful for you. As always, if you have questions about the material, please don't hesitate to contact me. My email is cgroover@collin.edu, or better yet, stop by. I'd love to talk to you in more detail about these topics. Thanks for your attention, and I hope that you have a wonderful day.